Big shout out to Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there. How about that?
Attorney Jaffe, are you ready?
I'm sorry, Your Honor. Yes, I'm ready. I have technical difficulties. My apologies.
Recall Gray.
Calling case 240556781. The people of the state of Michigan versus Walter Gray. Defendant is charged with count 1, homicide, murder, 2nd degree, count 2, weapons, felony, firearm. Today it is date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
And good morning again to the court, Your Honor. Attorney Brent Jaffe, P81818, retained counsel on behalf of Walter Gray.
My understanding that Mr. Gray is not going to be presented today based on a personal safety issue at this time.
Yeah, correct, Your Honor. I did hear that as well from the clerk. So I guess at this point, I'm not sure if I have any leg to stand on in terms of a bond reduction. If I do, I'd be asking for a reduction.
Okay. Well, I mean, you can make an argument.
Yeah, sure. Thank you, Your Honor. I would just say, Your Honor, Mr. Gray, he's 22 years old, no prior criminal history, a tremendous amount of family support, and again, presumption of innocence, Your Honor, and retained counsel. I spoke with Mr. Gray on numerous occasions, from the time he's been charged until really most recently, yesterday. And Your Honor, I guess we're asking that Your Honor consider a reduction in bond, and then again taking into consideration the presumption of innocence, Your Honor, because I do think that from what I know about this case, it's a very triable case on behalf of my client. So for those reasons, Your Honor.
Court haven't heard the argument of counsel. Court finds the $750,000 bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing by clear and convincing evidence that the defendant is a danger to the community, the complaining witness, or flight risk. In this matter, the allegations of 2nd degree murder obviously poses a danger to the community, not to the complaining witness, because the witness is deceased. Court finds the $750,000 bond is an appropriate bond. Bond will continue.
Thank you, Your Honor. And is Madam Prosecutor, is that the prosecutor that's the prosecutor of record, or just for your courtroom?
I'm just here for today.
Oh, okay, thank you. I'll see the discovery. Okay, thank you very much.
Mr. Reagan.
Judge, this is a case, I'm simply just asking for a small reduction, some type of cash bond. My client's in the MDOC. He's going to be there for a while. His bond's $300,000 cash. I just think that's a little excessive. So I'm just asking for a small reduction, Judge, some type of non-bond.
Miss Douglas.
Your Honor, he is in MDOC. However, if we look at the allegations, considered priors, we do think he's a danger. I mean, we're not anticipating him getting out. We just don't see a rationale for reducing it.
Okay, when is his out date from MDLC?
He's currently serving 2 to 10, 12/2/25, Your Honor.
We would point out that his, sorry.
What?
No, I was just going to point out that with Mr. Miller, the alleged assault happened relatively recently to when he was supposed to be in prison, Your Honor, and then that's what gives us concern about his danger to the public.
He's going to be in prison for next year, so I mean,
Bond is reduced to the amount of 30,000, 10%.
Thank you, Judge.
And a no contact provision with the complaining witness.
Yeah.
Thank you.
Okay, Mr. Miller, you're all set. Calling case 24055644401. The people of the state of Michigan versus Messiah Amerson. Defendant is charged with count 1, weapons, firearm, discharge in or at a building causing injury. Count 2, assault with intent to do great bodily harm, less than murder, or by strangulation. Count 3, weapons, dangerous weapons, carrying with unlawfully intent. Count 4, assault with a dangerous weapon, felonious assault. Counts 5 through 8, weapons, felony, firearm, habitual offender, second offense notice. Today is the date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
May it please the court, Your Honor, breaking on behalf of Mr. Amerson, who's appearing via Zoom for bond redetermination.
Amerson. What's Mr. Amerson's bond?
300,000 cash surety, GPS tether, house arrest.
Argument.
Judge, he's 36. I'm not seeing, Judge, and I can be wrong, any assaultive history. He's on probation right now, non-reporting probation to Macomb County for a non-assaultive property crime, Judge. He has 6 children. He works every day, does home health care, makes a living, supports his kids. Judge, obviously 8 counts is a lot of counts, but I'm asking the court respectfully reduce the bond. He has a lot of medical issues. He says that he's due to have brain surgery very soon as well, Judge. The complaining witness is a person at the gas station. So I'm asking the court to consider personal bond, GPS tether, house arrest, medical only, that he can go to his medical appointments and deal with those medical appointments, Your Honor. I don't see any, like I said, any assaultive history, just some theft crimes. And again, he's on a non-reporting probation to Macomb right now.
Argument.
Your Honor, we're asking for that bond to stay the same. This is highly assaultive. There's a lack of provocation. It involves a firearm. We do think he's a danger to the public. We would point out that Mr. Amerson was actually supposed to be getting arraigned last week on a different case, including a refusal to fingerprint. This was the second time of trying to arraign him on that. He would not cooperate with getting arraigned. And if I remember correctly, he actually tried to spit on the deputies at some point. Your Honor, we have concern in that him refusing to get fingerprinted indicates that he will not appear for court as required if he can't even comply with that. So, Your Honor, given the violent nature of the accusation, given that he would not even cooperate with getting fingerprinted, or last week when he was supposed to be getting arraigned, we do have concern for the public and him complying with restrictions, even if he does have a tether on, because that won't keep him from going anywhere. It'll just alert if he goes someplace. So we're asking for that bond to stay the same.
Judge, I don't have any knowledge about him not fingerprinting. I don't know about that part. I can say that he's here, charged. He got cases.
You can look it up. The date of offense is February 7th. Oh, sorry.
It's okay, Ms. Douglas. Court haven't heard the arguments of counsel. We have before us a defendant who's currently on probation, who's alleged to have walked into a gas station and pistol whipped someone in a gas station and shot them in the foot. I don't really understand the fact pattern.
More to it.
Yeah, I don't understand the fact pattern. But what I do know is that, we do need to be on our best behavior when we're on probation and go through our conditions and do all that stuff. And pistol whipping, having firearms, I'm sure is not part of anyone's probation that you get to have firearms, whether you pistol whip someone with provocation or self-defense, or you don't pistol whip someone. It's just, it's a lot here. Court haven't heard the arguments of counsel. Court finds a $300,000 cash bond is an unaffordable bond. Court finds that in order to have an unaffordable bond, there has to be showing by clear and convincing evidence that the defendant is a danger to the community, the complaining witness, or a flight risk. Ms. Douglas is arguing he's refusing to be fingerprinted. That shows a possible flight risk. I don't have any evidence of that, but the fact that he would, allegedly pistol whip someone in a gas station on video makes it seem as a little bit dangerous. But that being said, court's going to reduce the bond to $300,000, 10%, with GPS tether, house arrest, and he can leave for medical appointments and court appearances only, and a no contact with the complaining witness. Thank you.
Thank you.
Bill.
And Your Honor, just for the record, that failure to that refusal to fingerprint is actually charged.
Okay.
And he was supposed to be arraigned on that last week, but he wouldn't cooperate.
Okay. Got it.
Okay,
Thank you.
Mr. Emerson, you're all set. Thank you. You're all set.
Calling case 24055680101. The people of the state of Michigan versus Lamar Mitchell. Defendant is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, assault with a dangerous weapon, felonious assault. Habitual offender. Third, offense notice. Today is the date and time set for bond redetermination. Appearances, please.
Jennifer Douglas for the people, P72748.
Deliberate on behalf of Mr. Lamar Mitchell, Judge.
That's exactly what she told me. She said,
What is his name? One more time.
Lamar Mitchell.
Lamar Mitchell. I'm sorry. And where's Mr. Mitchell's bond?
50,000 cash as surety, GPS tether.
Argument.
Judge, my client's 37 years of age. He's not on probation or parole right now. The judge does have some priors, one from 2009, one from 2022. He works at Bar Louie. He's a chef. He also is a cook at the Liger House. So he has 6 children. He supports Judge. And honestly, to tell you honestly, Judge, he has stab wounds in both of his hands, stab wound in his shoulder, stab wound in his thigh. He says he was stabbed on the ground. Multiple people were on top of him, Judge. When they dropped the knife, somebody dropped the knife, he just started trying to get folks off of him. It was more of a reaction than anything, Judge. If you look at his hands, you see the stab wound in his hands, So, this is a case, Judge, where the interpretation is going to have to be dealt with by his lawyer when the arguments come to court. But he maintains his innocence in terms of any intent of trying to purposely hurt anyone. I'm asking for a reduction. So he can go to work, 50,000 personally, go take care of his kids and take care of whatever medical situations he has as well.
Okay. This is one of those where I need a little clarification. So, allegedly, the defendant asked to borrow a witness's car. She says no. Allegedly, he breaks out the window of the car with a brick. Allegedly, goes on the porch and he's fighting with someone. Allegedly, some women come to break up that fight and detain him. And then they notice that the other guy is bleeding from being stabbed. Is that what I'm getting? Am I close or? You're muted.
Oh.
Phil, you're muted.
Oh.
You're doing a lot over there, Phil, but we can't
I'm
hear
sorry,
you.
Judge. You are close, Judge. You are close, but they come and they jump on him and they start stabbing him. But he gets the knife away and he gets people off of him. He's trying to get people off of him. And that's how some other stabbing comes. But you're close, Judge, on that.
Okay. All right, Miss Douglas.
Your Honor, we're asking for this bond to stay the same. We disagree of people jumping the defendant. Uh, the allegations are not just that the defendant stabbed the victim, but that there were so many stab wounds that the doctors actually couldn't tell how many there were. He was taken to the hospital. The complaining witness, he had to have surgery, and the doctors, while they couldn't figure out how many stab wounds there were, they did indicate to the police that the complaining witness had stab wounds to his right forearm, his left shoulder, his left ear, his left kidney, his left lung, his diaphragm, and his spine. So the idea that somehow he was just stabbing whoever happened to be on top of him seems less likely if he was able to hit all those different spots. And I know that Mr. Reagan says that actually it is the defendant who was attacked and hurt with four people trying to assault him. But if there are four people trying to assault him, it seems unlikely that he would be able to stab somebody else that many times without anybody stopping him. So it seems unlikely that everybody was jumping on the defendant. The complaining witness is very seriously injured to extent he could have died. And so, Your Honor, we do think there's a danger there. Right now, that's the last known address that the defendant had at this location. We think that there's a danger there. There appears to be a lack of provocation. So, Your Honor, for the safety of the complaining witness, for the safety of the other people in the house, and for the public, we're asking for that bond to stay the same.
What seems unlikely is that Mr. Mitchell's going to stab himself in the hands. Go like this, Mr. Mitchell. It seems unlikely he's going to start stabbing himself, Judge. Hey, I don't know what seems likely, but again, it's two sides to every story, and it's going to have to play itself out. But his story does seem plausible, Judge. So, I'd ask the court to look at that as well.
And the court will. Court finds the $50,000 cash bond is non affordable bond. The court finds that by clear and convincing evidence that the defendant poses a danger to the complaining witnesses. I'm not really sure. Allegedly, again, he was so upset that he couldn't use a woman's car that he took a brick to the back window. That the denial of the use of one's transportation allegedly made him break out a window of a car, and then that kind of was the stimulus for him being stabbed, I guess, him stabbing someone else, and kidneys and lungs and forearms, and him being detained by two women. It's a lot. With that being said, the court finds the $50,000 cash bond is excessive. Court is going to reduce the bond to $50,000, 10%. GPS tether, 10 p.m. to 6 a.m. curfew, and a no contact with any of the complaining witnesses. Thank you.
That's Mr. Carter at the bottom. We're about to call this case. Your name's Mr. Carter, right?
Yes.
Okay.
Calling case 240-556-3301. The people of the state of Michigan versus Jason Carter. Defendant is charged with count 1, criminal sexual conduct, first degree personal injury, sword notice. Count 2, assault with intent to do great bodily harm, less than murder by strangulation. Count 3, domestic violence, habitual offender, second offense notice. Today is the date and time set for violent redetermination. Appearances, please.
Good morning, Your Honor. Brent Kurt on behalf of the people, P84009.
May it please the court, Your Honor, Reagan on behalf of Jason Carter.
Carter, state your name for the record.
Jason Carter.
Argument, Mr. Reagan.
So, Judge, if you read the report, it's the hearsay document. The report reads horrible. It reads like, my client doesn't have any compassion, doesn't care about anything, just doing what he wants to do. That's how the report reads. That's how I expect, most hearsay documents to read when people are trying to probable cause for 4K. I mean, obviously there's a relationship. They were in bed together. It says they have kids together. It says he goes through the phone, sees text messages, gets upset, and then he gets angry, and these, things start to happen. His conduct starts to happen. He has sex. I guess she doesn't want to have sex. But then Judge, I look at all this other stuff added, spitting, and I'm going to kill you. I'm going to do all this other stuff on phones. Then she says, well, I just want to go get some medicine for our son. He said, okay, go. Not a problem. You're going to come back. So, a lot of this stuff doesn't, it doesn't add up, because if I'm committing crimes of this heinous nature, I'm probably not going to want somebody to just leave and come back. But he says, okay, leave. And then what she doesn't do, Judge, she waits a whole day after this to go to the hospital, which seemed a little odd to me. I mean, it seems like, as soon as you get a chance to leave, you're going straight there, so I don't know. And maybe I'm not reading it correctly, but it seems like she waited a day to go to the hospital. But I don't know the relationship between Mr. Carter and Ms. Andrews. Obviously, they have a child together. They've been in a relationship because they do have a child together. Obviously, anytime a alleged crime is committed, it's serious, no question. But again, there's always two sides to every story. Certain facts have to come out. This case is going to matriculate. His bond is $1 million. I think the $1 million is excessive, Judge. I would ask for some type of reduction.
Court having heard the argument of counsel, court finds that that the $1 million bond is an unaffordable bond. In order to have an unaffordable bond, there has to be a showing of danger to the complaining witness, the community, or flight risk. With these allegations, the court finds that the defendant is a clear danger to the complaining witness. Allegation is Mr. Carter went through the complainant's phone, not his phone, someone else's phone, and allegedly found out that the complaining witness bought somebody a Nike Tech Fit, and the fact that she bought an expensive Nike jogging suit, not the regular jogging suit, but the Tech Fit, that's the higher end one, that caused him allegedly to be angered, and that he anally raped her for buying the Nike Tech Fit for someone else, and allegedly spit on her, called her a whore, and things of that nature with his children around. And so allegedly threatened to have her grandmother's her jaw or mouth wired, and stated that he would only do 6 months for this, and that he would be back. With those allegations, mere allegations in a hearsay document, court does find that the defendant is a danger. Court find, what are the other conditions besides the $1 million bond? Madam Clerk?
GPS tether, house arrest.
Okay.
And Your Honor,
one second. I'm still talking. Just to make sure I'm clear, it was $1 million and house arrest, GPS
Correct.
tether. The bond continues. Madam Prosecutor, what would you like to say?
Your Honor, I think it should also be taken into consideration that Mr. Carter did have a failure to appear warrant at the time these alleged offenses occurred, and additionally was already on bond and tether for other assaultive cases against a different ex-girlfriend that are currently being tried up here at the circuit court in front of Judge Gillis. And I do think that those are additional factors that are important for the court to note. And I would ask that you leave the bond.
I'm saying I've already continued the $1 million bond. Is there
Yes.
any? Are you asking me to do something to add to that, or just
No,
you just want?
No, Your Honor. I think that just those additional factors should be stated on the record.
Okay, duly noted. Again, bond continues.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.